員、委員早晨，大家好。
Members, good morning. I call to order the meeting of the Bills Committee on Registration of Same-Sex Partnerships Bill. This is our third meeting. We have a quorum and it's the scheduled time. Let's get started. I'll ask the Secretariat to invite the government representatives to join us first.
好，咁我哋先前
Some issues to be followed up from the previous meetings. In the letter dated on the 22nd of July, provided by the administration, the issues have been addressed. Please refer to LC paper number CB bracket 2 1535/2025 bracket 01 and bracket 02. When we come to those parts, the administration will walk us through the reply during the clause-by-clause scrutiny. Let's carry on with the clause-by-clause scrutiny now. We will look at the Chinese version of the Blue Bill first. If members have any questions or views concerning the English text, please raise them. If members have any questions during the clause-by-clause scrutiny, please press the Request to Speak button. Please leave some time for the administration to reply to your questions. I'll give each member 3 minutes, including questions and answers. Before we concluded the previous meeting, we stopped at Clause 6 of the bill. Members, do you have any further questions on Clause 6? If there are questions, we can look at Clause 6 again. If not, I will ask the administration to carry on with the clause-by-clause scrutiny. I'll ask them to walk us through the clauses. I'll also ask legal advisor to remind us of any drafting issues. There's a strong correlation between each clause. So I will ask the administration to perhaps walk us through a few clauses at the same time, and we can focus on our questions on those clauses. Now we look at clauses 7 and 8. I'll ask the government representatives to walk us through this part. Deputy Secretary, thank you. Clause 7, mode of application. Page C3784 of the Chinese text and C3785 of the English. Subclause 1. A same-sex partnership registration application must be made by the parties by notice to the registrar in the specified form. Subclause 2. A same-sex partnership registration application must be accompanied by A. Any document and information specified by the registrar, and B. The prescribed fee. Subclause 3. The registrar may issue a written direction to the applicants of a same-sex partnership registration application to require the applicants to provide any additional document or information in accordance with the direction. Subclause 4. Also, the registrar may issue a written direction to the applicants. A. To require the applicants to, in accordance with the direction, produce any document for inspection, including producing the original or certified copy of any document for inspection. And B, to require the applicants to, in accordance with the direction, each take an oath before the registrar to the effect that the oath taker believes that all conditions mentioned in Section 6 are met in respect of the same-sex partnership registration that the parties are applying for. Clause 8. Completion of registration. The registrar may effect a same-sex partnership registration for the parties in accordance with Section 9(2) if the registrar is satisfied that A, the requirements and any directions issued under Section 7 are all complied with in relation to the same-sex partnership registration application. B, any oath taken for the application in accordance with such a direction is in order. And C, all the conditions mentioned in Section 6 were met when the application was made. Thank you, Deputy Secretary. I see that 4 members have asked to speak. Mrs. Regina Ip, please. Thank you, Chairman. Clause 7 states that a same-sex partnership registration application must be made by the parties by notice to the registrar in the specified form, and a prescribed fee will have to be paid. If there needs to be a specified form, usually there will be a schedule in the bill listing out the format of the specified form. Also, oath-taking is mentioned a number of times here. What kind of wording will be used in the oath? How will oath-taking be conducted? And also, will that have to be compliant with Cap 11, Oaths and Declarations Ordinance of our laws? These are not specified here. Deputy Secretary. I thank Mrs. Regina Ip for the questions. On oath-taking, I will ask my colleague Ms. Wong to reply. As for the format of the specified form, indeed, both parties will have to submit a form that is specified by us. Apart from paper-based form, we will allow for the submission of electronic forms. As mentioned last time, if the bill is passed, well, we have already talked to the Digital Policy Office, and we have already talked to them about it, about the design of the forms and procedures. We'll have to work with the office on the interfacing of the paper-based forms and the electronic forms. We will require applicants to fill out certain information on the specified forms. We will set out the details through administrative measures. There will be application guidelines on the dedicated website. We think it is appropriate to set out the formats and relevant details on the dedicated website. Ms. Wong? Indeed, the oath-taking will be conducted in accordance with Cap 11, the Oaths and Declarations Ordinance, so the relevant format will have to be compliant with the ordinance. If this bill is passed, we will disseminate very clear guidelines to the public about the oath-taking. Just one more point, Chairman. That means the specified form as well as the oath-taking procedure will be set out in the future guidelines, right? So there will be a specified form, it's just that you haven't listed out the details, right? Yes, we will explain this clearly to the public in the future. Okay. Dr. Lo Wai Kwok, thank you. On the mode of application, I'd like to go back to Clause 6, Conditions for Registration. the conditions are rather lenient. So as long as you have reached 18 and you are a Hong Kong resident and you have a valid same-sex partnership registered outside Hong Kong between the parties, then you can obtain the registration in Hong Kong. According to the interpretation, any marriage, civil partnerships, or civil union could be conducted in person or by remote means. So people with ulterior motives, they may set up an online company overseas. They may make use of the online companies to help people get registered for their same-sex partnerships or same-sex marriages. Then those who get married overseas, they can obtain registration in Hong Kong. So we are providing a way for people to recognize same-sex marriages legally. Well, we will come to this part about registration, and those who have obtained the registration, there will be certain rights that they get in relation to the medical procedure and death-related matters. Well, if you have opened this store, that means we will provide to them the social benefits as well as the right to apply for public housing. So what I want to stress is that people will be able to get married outside Hong Kong by remote means. So you don't even have to fly elsewhere, you can do it online. There might be people with ulterior motives who set up companies online to conduct such business. This is a question I have in mind. Deputy Secretary, I thank Dr. Low for the questions. I understand his concerns. Let me give a simple reply. Under Clause 6, there are 6 conditions to be met. The registration will only be valid if all the conditions are met. There are some very objective requirements. We have drawn reference from the practices in other jurisdictions, and we try to strike a balance based on the actual circumstances in Hong Kong. Also, we ask same-sex partners to have their relationships registered outside Hong Kong, and we only recognize overseas registration carried out by official authorities. So it's not that we will recognize any registrations obtained overseas by a random organization. This is a solemn matter. So only registration obtained from official authorities overseas will be recognized by us. Now, under this same-sex partnerships registration system, we have to confer to same-sex partners their rights. And according to the CFA judgment, we can exercise discretion to provide them with the rights under the bill. We are including the core rights of same-sex partners, including getting up registration, having their registration revoked, as well as the rights to deal with their partners' medical procedures and so on. As for other benefits, such as the right to apply for public housing, as you may have noticed, there are some judicial review cases that have to do with same-sex partners' rights to apply for public housing. And we will stick to the judgment made by the court when we make the relevant decision.
Thank you. Chairman, I'll be quick. In overseas jurisdictions, the registration of marriages is very lax. These could be done by religious organizations, not necessarily by the government. if we allow this, in other words, if there may be marriages registered by religious organizations, then this will open the floodgates. Secretary: Thank you. As I mentioned at last meeting, same-sex marriages are one of the ways to recognize same-sex partnerships. In overseas jurisdictions, when there is a registration of same-sex partnerships or marriages, then we recognize the relationships of the same-sex couples. We don't recognize the marriages of the same-sex partners. In our entire registration mechanism, or the rights conferred as a result of the mechanism, I have to once again emphasize the recognition of the partnerships is different from that of marriages. We draw reference from the overseas jurisdictions law and we take into account the circumstances of the relevant overseas jurisdictions. If the online mode is used in an overseas jurisdiction, then we take into account this method. That is the method in practice in the overseas jurisdiction concerned. That's the case. Clause 7(2). Should subsidiary legislation be used to specify what kind of document or information should be specified by the registrar? Is that more appropriate? In other words, should the document or information be specified by way of subsidiary legislation? Deputy Secretary, can you explain further? Can you clarify? Thank you. When it comes to specified document, we need to determine the format of the document. Application form, requests for supplementary information, invitation to take oaths. There are different types of documents. In the process, we will also be making enhancements. There won't be just one single document or type of document. The registrar will decide the information or the document's format. This is a more proper approach. Thank you. Ms. Nick Z. Lam. Regarding clause 7(3) and (4), the registrar may issue a written direction to the applicants of a same-sex partnership application to require the applicants to provide any additional document or information in accordance with the direction. What kind of document are you referring to? What are the differences between the documents set out under clause 7(3) and (4)? Under clause 4b, the applicants will have to take an oath each. Does it mean that they can take an oath separately? Do they have to go to the register together? Thank you, Ms. Lam, for your questions. Regarding your first question, in handling applications, the registrar will take into account the documents as mentioned under clause 6 to require what kind of documents to be submitted for verification by the registrar. But of course, the registrar may issue a written direction to the applicants to require the applicants to provide any additional document or information in accordance with the direction, taking into account the application. Clause 7.4a, the registrar has the power to require the applicants to produce any document for inspection, including the original copy or the original or certified copy for inspection. The applicants may submit the electronic copy at the first instance. Then the registrar will have to read the original to verify the said e-copies. This is a strict requirement in relation to verification or inspection of the copies submitted. Clause 7.4a and 4b are interrelated. The applicants, when they take an oath, will have to submit the documents to the registrar. Then they will have to take an oath. We need to have regard to the background of the applicants. We need to make it convenient for them to come to the registrar's office to take an oath. Therefore, applicants may come to take an oath together or separately, but the registrar's office will wait until both of them have finished the oath-taking procedures before the registration certificate will be issued. Documents will also have to be ready by then. Mr. Vincent Chang. Thank you. For the first-time registration, applicants don't have to visit the office in the flesh. They can submit the application online. But when they need to meet with the registrar, they have to physically visit the registrar's office. My next question is very solemn. Hong Kong has very solemn requirements when it comes to marriages. Other jurisdictions may have simpler requirements. Sometimes some documents are forged. We don't know the veracity of the documents yet. In this case, how do we handle these cases? What are the consequences of these forged documents? Well, I will ask Ms. Wong to take the question in relation to forged documents. Regarding the first question, we allow the submission of documents by applicants in the flesh, but we will also be providing an e-platform for applicants to submit documents on the internet. In this case, we may not be able to check the original of the e-copy, or we may not be able to verify the certificate. That's why, in the oath-taking stage, we require the applicants to bring together with them the original or certified copy of the document they have submitted. As Mr. Chang mentioned, this is a solemn ceremony, and it will have to seriously inspect all the documents to make sure they are real, authentic documents. Ms. Wong, please. In case of false representation, first, in the oath-taking procedures, if they make false representations, then they will have to be subject to criminal liability. In accordance with Section 32 of Cap 200 Crimes Ordinance, the maximum penalty is imprisonment of 7 years. In case of forged documents or false representations, the person concerned will also be held criminally liable in accordance with the same provision under Cap 200 Crimes Ordinance. In accordance with Section 36 and Section 73 under Cap 200 Crimes Ordinance, the person concerned will be liable to imprisonment of 7 years or 14 years. Under what circumstances will the registrar require the applicants to take an oath? Is that a necessary procedure? Well, let's refer to clause 7 bracket 3 and bracket 4. 7.3. This is a basic procedure. The registrar requires the applicants to submit ID copies, passport information, or certificate issued by overseas jurisdictions. There may be more documents required depending on the circumstances. That's why we have bracket 4. That is when the registrar may require more information or documents to be submitted by the applicants. When the applicants need to submit the original to the registrar, then this is in accordance with clause 7 bracket 4. You may refer to clause 7 bracket 4a for inspection. The registrar may have to inspect the original of the online copy, and this is dealt with in clause 7 bracket 4. Next member, Mr. Kenneth Lau. Thank you, Chairman. I'm exchanging views with other members. For heterosexual marriages registered outside Hong Kong and recognized in Hong Kong, I'd like to know the differences between the procedures of heterosexual marriages and homosexual partnerships. As for registration of same-sex partnerships, this can be registered online. So is this method simpler compared with the procedures for heterosexual marriages? In these two meetings, we talked about the recognition of same-sex partnerships or same-sex marriages registered in overseas jurisdictions. Is it possible for us to just recognize relationships or marriages or partnerships entered into when they visit the relevant overseas jurisdictions in the flesh? If some overseas jurisdictions recognize online marriages or partnerships, can we only recognize the partnerships or marriages entered into when these people concerned go to the overseas jurisdictions in the flesh instead of registering the marriages or partnerships online? Applicants may submit the application either online or physically in the office. In light of technological advancements, we do have the responsibility providing the option of online submission. However, when it comes to inspection of documents and oath-taking, we understand it's kind of risky when we recognize an application or approve an application when it is only submitted online. That's why we require the applicants to come to the registrar's office to take an oath before the registrar. We need to verify whether these two applicants are the real applicants before the registrar. There will also be oath-taking arrangements to confirm the arrangements and to formalize the procedures. We take into account the rules and laws in different overseas jurisdictions. If there is a formally recognized registration arrangement in an overseas jurisdiction, this will be the key consideration of ours. Is it done in the flesh or is it done online? That is the factor we take into account. That is indeed the prime factor we take into account. We want to provide convenience to applicants when we allow them to submit the application electronically. However, for most jurisdictions, they require registration in the flesh. Thank you.
think the administration didn't really reply to my first question. I want to compare the procedures for heterosexual couples to get married overseas and obtain registration in Hong Kong with that set out under the bill. As far as I understand, heterosexual couples who get married elsewhere, they do not have to obtain registration in Hong Kong. They only need to update their information with the immigration department, so the procedures are different. Well, submitting documents to the immigration department is also a procedure. Will they have to complete the procedure in person? Secretary, I have to stress again that this is a registration system for same-sex partnerships. This is completely different from the marriage system. There is no need to compare the two. Also, under this proposed registration system, in terms of our design, we try to provide convenience to the applicants, and there are stringent requirements and procedures imposed to certify the documents. So I think there is no need for us to compare the existing marriage system with this registration system. Next, Dr. Eric Yim. I have questions about marriages conducted by remote means as well. According to the administration's document, same-sex couples can have their partnerships registered overseas, and we will grant registration to them in Hong Kong. For those with disabilities or with mobility issues, they will have to have their partnerships registered by remote means. So can you allow for couples with disabilities to have their registration obtained by remote means? Ms. Phyllis Wong, according to our law, people will have to comply with the Oaths and Declarations Ordinance. Under the ordinance, applicants will have to take oath before the registrar in order to comply with the law. You may also do so before the registrar by remote means, as long as you can verify the applicant's identity. Will you allow this to be done by remote means? Mr. Mui, I thank Dr. Yim for the questions. Perhaps I can supplement here. We will ask applicants to take oath before registrar. And this is in line with the Oaths and Declarations Ordinance. Under the ordinance, oath is taken before the person who has the right to supervise the oath-taking procedure. So we are sticking to the existing systems when we propose this system. Dr. So Chun Wing, I have a simple question about the registration procedure. Normally, from the submission of application to the completion of the application procedure, how long will it take? Second question. The bill is asking applicants to take oaths before obtaining registration. This is a very solemn procedure for granting same-sex partners the legal status. So I have this following question. Oftentimes we have to submit declaration documents and forms, and oftentimes we have to fill out the column about marriage status. You have to declare whether you are unmarried, married, or if you are in a different status, will you add this column to the future forms? Deputy Secretary, you need to go through certain procedures when you submit applications. So we will ask applicants to submit certain documents and information in future. The time to be taken really depends on how quickly the applicants submit the documents. If the applicant, for example, is overseas, then we may ask the applicant to provide supplementary or additional information. So it's hard to say at this point how long the procedure will take. Based on the actual circumstances, we hope to have the applicants complete the procedure within a certain period of time. Your second question is about forms. That is, how can same-sex couples or partners declare their identity in future forms? If the bill is passed and if the ordinance takes effect, we will take a series of administrative measures. We will have to update or revise relevant forms. Thank you. Now we'll proceed to clauses 9 to 11. Deputy Secretary, please. Thank you. Please turn to C3786 of the Chinese text and C3787 for the English. Subdivision 2, Same-Sex Partnership Registration Certificates. Clause 9. Preparation, issuing, filing and registration of same-sex partnership registration certificates. 1. The registrar may, for the purpose of Subdivision 1, prepare a certificate in the specified form in duplicate. 2. For effecting a same-sex partnership registration, the registrar must A. Issue one same-sex partnership registration certificate to the parties to the same-sex partnership registration application, and B. File the other one in the registrar's office. 3. The registrar must register all same-sex partnership registration certificates filed in the registrar's office in the order and manner that the registrar considers best suited for easy reference to the certificates. 4. Without limiting subsection 3, the registrar may record the same-sex partnership registration certificates in the form of a digital image. Clause 10. Effect of same-sex partnership registration certificates or their certified copies. 1. Any same-sex partnership registration certificate filed in the registrar's office is admissible as evidence of the same-sex partnership registration to which the certificate relates, A. in any court, or B. before any person having, by law or by consent of parties to the relevant proceedings, authority to hear, receive, and examine evidence. 2. If a copy of a same-sex partnership registration certificate filed in the registrar's office, including any copy in the form of a printed copy of the digital image of a same-sex partnership registration certificate, is purported to be signed and certified as a true copy by the registrar, and to be sealed or stamped with the registrar's official seal, the copy is admissible as evidence of the same-sex partnership registration to which the certificate relates, A. in any court, or B. before any person having, by law or by consent of parties to the relevant proceedings, authority to hear, receive, and examine evidence. Clause 11. Correction of errors in same-sex partnership registration certificates. The registrar may correct any clerical error in any same-sex partnership registration certificates produced to or kept by the registrar, but the registrar must authenticate the correction by the registrar's signature or by marking the registrar's initials and must denote the date of making the correction. I see that 3 members have asked to speak. Ms. Nixie Lam, please. Thank you. I'm looking at clause 9 bracket 4. It says the registrar may record the same-sex partnership registration certificates in the form of a digital image. Does that mean if a paper-based certificate is requested, the registrar may issue a paper-based certificate as well? Clause 11 is about correction of errors in certificates. Does that mean the certificate with errors will be revoked, or will the applicants be asked to deal with the certificate with errors by themselves? Deputy Secretary, there will be 2 copies granted to the same-sex partners. 1 copy of the certificate will be kept by the applicant, and another copy will be filed by the registrar in the registrar's office. And this is the usual way to deal with official documents. If the applicant asks for 1 more copy of the certificate, we can, through clause 22 bracket 1b, that is, if the registrar approves and if the applicant pays the fee, we will issue another certified copy. Sorry, that's clause 22 bracket 1c that I'm referring to. And the certificate will be in the form of a paper. We won't issue a digital copy of the certificate because we want to prevent people from misusing the certificate. How about a certificate with errors? Will those be recalled? Well, there will be a date of issuance on the certificate, and the certificate will cover the powers to be conferred to the applicants. For example, if there are errors in the certificate, be they discovered by the registrar or the applicants, we will correct the errors in order not to affect the rights to be conferred to the applicants. So we will correct the errors and we will ask the applicants to countersign them. That means the original certificate will not be collected by the registrar. Well, we will make errors on the original copy. So you will not issue a new copy. That's right. Dr. So Chun-Wei, thank you. I have 2 questions. First, on clause 9 bracket 2. It says here that the registrar must file the other copy of the certificate in the registrar's office. Can authorized persons or other people be allowed to inspect the registration or the certificates? Also, I want to seek clarification on clause 9 bracket 3. I don't quite understand this part of the bill. Deputy Secretary, I thank Dr. So for the questions. On his first question about who will be allowed to inspect the certificate, clause 22 talks about how registrar can inspect the relevant documents or instruments. We will allow applicants to search the papers or forms they had submitted in case they had lost their own copies or their own copies had been damaged. So we will allow applicants to check their copies in the registrar's office.
Well, sorry, I mean for ordinary people or authorized people, not the applicants themselves. I believe they will be able to access the relevant documents. But what about when someone wants to check whether someone else has such registration records? Well, Dr. So, I was about to go into this point. For authorized third party, if they do have the written authorization, then this is acceptable. However, for people who have no relationships with the applicants, then in general we don't accept such requests. Well, can you tell for sure, not just in general? For usual or general government documents, members of the public do have access or the right to access such documents. Well, as the documents concern personal particulars or information about the same-sex partners of the relevant applicant, hence the requirements or restrictions in this regard. Under Clause 9, Bracket 3, the registrar must register the certificates in the order and manner that the registrar considers best suited for easy reference to these certificates. In the registrar's office, there are not only electronic records, but there will also be paper records. The registrar does have the responsibility for keeping these paper records, and there will only be more and more such records. Well, I do understand bracket 4. I was asking about bracket 3. For electronic copies, there shouldn't be any problems. However, when it comes to paper copies, there needs to be good categorization of the paper documents. That's why we set out clearly that the registrar must register the certificates in the order and manner that the registrar considers best suited for easy reference. Thank you. Mrs. Regina Ip. This time I agree with Dr. So. A lot of information in Hong Kong is open. Well, when I was serving as the Director of Immigration, there were paparazzi requesting information about the marriage records of a high-ranking official of the government. It's different from Clause 22. The power is vested with the registrar. In the principal legislation, you don't settle this, and you may be subject to judicial reviews. But of course, I'm not just talking about paparazzi. If the registrar exercises power in an inappropriate manner, then the registrar may be subject to judicial review. Thank you. Regarding Clause 22, Brackets 1a, the registrar may allow searches to be made amongst instruments in the registrar's possession for the purposes of this ordinance. The information contained therein is very sensitive. It concerns personal particulars as well, so in general, it will not be disclosed to the third party. But of course, on very special grounds, say when public interests are involved or at the request of the court, we will consider handling this information. We will handle this information in this manner. Mr. Sip, well, I don't think this information is very sensitive. The information is open, just like when someone takes wedding photographs with their family members. Well, Secretary, you served as Director of Immigration. You are very clear about this. When it comes to, say, birth certificates or death certificates, is the registration of birth and death open information? Well, this may not be the best comparison. I need to take a look at the latest practice of the Immigration Department, but as far as I understand, for registration of marriages, the information is only available to the applicant, that is the subject person's authorized third party or family members. On special grounds, the registrar may give special consideration, say when probate is involved. Otherwise, it won't be open to public access or public inspections. Well, with reference to the company's ordinance, company information is subject to inspection and public access. The requirements are different. On this occasion, we need to take into account privacy. And at present, we only allow the applicants themselves or a third party authorized by the applicants, and so on. Only on special occasions do we give discretion. Thank you, Chairman. Well, I'll have to have regard to the marriage ordinance first. Thank you. I'd like to talk about Clause 10(1)(b) and 2(b). Before any person having, by law or by consent of parties to the relevant proceedings, authority to hear, receive, and examine evidence. Do you mean a lawyer, a doctor, or who? Deputy Secretary. Well, I will ask Ms. Wong to take this question. Thank you, Chairman, for your question. Authority to hear, receive, and examine evidence. It means someone has the authority to receive and examine the evidence to determine whether the evidence is admissible. And of course, a judge is an example. A lot of statutory organizations in Hong Kong also have such powers. Members of the public may know that these examples also include Administrative Appeal Board, Liquor Licensing Board, Appeal Tribunal, and so on. They do have similar powers as conferred on the judge of a court. We cast the net wider to cover all these people. In relation to by law or by consent of parties to the relevant proceedings, well, for judges, they are empowered by the law. Whereas for by consent of parties to the relevant proceedings, the laws may not set out such requirements clearly enough. In some cases, when the parties to the relevant proceedings consent to such, this will also be allowed. We hope same-sex partners will be protected by law in different scenarios. Mr. Sip, I'd like to ask about Clause 11. In relation to correction of errors, we can see that the registrar may correct any clerical errors. Will a certified true copy be issued in case of a clerical error being corrected? Is it free of charge? Does one have to pay for it? Can the administration tell us the specifics? Thank you. Deputy Secretary. As we mentioned just now, when we identify clerical errors in the certificate, we'll have to correct the errors concerned. In that case, we will ask the applicants to bring to us the original certificate. We may authenticate the correction by the registrar's signature or by marking the registrar's initials and must denote the date of making the correction. We don't issue a new certificate to the applicants concerned. That is because the applicants may have already made an application using the certificate already issued. Some arrangements may already have been made. That's why we use the original certificate as the basis. We will also amend or correct the errors on the certificate that is being kept by the registrar's office. Well, I think that doesn't look good. You need to make corrections to the name of the applicants, and then the person concerned will have to take the certificate elsewhere to make application, for instance. These people have the courage to register their partnerships, and when you need to correct the errors on the certificate, I don't think it's very good. Chairman, just now we talked about Clause 9. We need to read Clause 22 together. What about the requirements and the fees for issuing a copy of the certificate? Could the legal advisor take the floor, please? Thank you. The registrar may issue a certificate, and then member asked whether a registrar will issue a copy. In some cases, a certified true copy may be required. Clause 9 doesn't refer to the issuing of a certified true copy. When a document is lost or when it is damaged, will a copy be issued? We need to take a look at Clause 22 together. Under Clause 22, the registrar may give a certified copy of any entry in those instruments. So what does it mean by a certified copy of any entry in those instruments? Does it mean the copy of the certificate? Or when one inspects the registration? Well, I don't quite understand about the certified copy you mentioned. Can you give us any clarification, Deputy Secretary? When the applicant submits the first-time application and pays $260, when it is approved, the original of a certificate will be issued. We only issue one set of the original. When one wants to apply for a second set, that is a copy of the certificate, then the applicant will have to make a request to the registrar in accordance with Clause 22(1)(b). After consideration, the registrar may give a certified copy of any entry in those instruments. Of course, a certified copy shouldn't be confined to just one of the certificates. In the entire process, probably the applicants want to apply for the certified copies of other documents as well. For certified copies, we charge $220. In other words, the applicants do have the power or the right, so to speak, to apply for an administrative copy. One doesn't have to pay fees once again if they make such requests. when they register for the first time. However, if after a period of time when they make such requests, they will have to pay a fee before they can get such copies.
亦都請啊
Deputy Secretary, please walk us through clauses 12 to 15. Thank you, Chairman. Please turn to C3790 of the Chinese text and C3791 of the English. Division 2, Revocation of Same-Sex Partnership Registrations. Subdivision 1, Revocation of Same-Sex Partnership Registration on application or on own initiative. Clause 12, Revocation of Same-Sex Partnership Registration by registrar on application at both parties' wish. 1. The parties to a same-sex partnership registration may, by notice to the registrar in the specified form, make an application for revoking the registration if A. The same-sex partnership registered outside Hong Kong on which the registration relies has not been terminated, but B. The parties both wish to revoke the registration. 2. The application must be accompanied by A. Any document and information specified by the registrar, and B. The prescribed fee. 3. The registrar may issue a written direction to the applicants of an application made under subsection 1 to require the applicants to provide any additional document or information in accordance with the direction. 4. Also, the registrar may issue a written direction to the applicants, A. To require the applicants to, in accordance with the direction, produce any document for inspection, including producing the original or certified copy of any document for inspection, and B. To require the applicants to, in accordance with the direction, each take an oath before the registrar to the effect that the oath taker wishes to revoke the registration. 5. The registrar may revoke a same-sex partnership registration in accordance with Section 16(2) if the registrar is satisfied that A. The requirements and any directions issued under this section are all complied with in relation to the application under subsection 1. B. Any oath taken for the application in accordance with such a direction is in order. And C. The parties to the same-sex partnership registration both wish to revoke the registration. Clause 13. Revocation of same-sex partnership registration by registrar on application where same-sex partnership has been terminated. 1. If the same-sex partnership registered outside Hong Kong on which a same-sex partnership registration relies has been terminated, the parties or a party to the registration, each party or the party being an applicant, may, by notice to the registrar in the specified form, make an application for revoking the registration. 2. The application must be accompanied by A. Any document and information specified by the registrar, and B. The prescribed fee. 3. The registrar may issue a written direction to the applicant of an application made under subsection 1 to require the applicant to provide any additional document or information in accordance with the direction. 4. Also, the registrar may issue a written direction to the applicant, A. To require the applicant to, in accordance with the direction, produce any document for inspection, including producing the original or certified copy of any document for inspection, and B. To require the applicant to, in accordance with the direction, take an oath before the registrar to the effect that the applicant believes the same-sex partnership registered outside Hong Kong, on which the same-sex partnership registration relies, has been terminated. 5. The registrar may revoke a same-sex partnership registration in accordance with Section 16(2) if the registrar is satisfied that A. The requirements and any directions issued under this section are all complied with in relation to the application under subsection 1. B. Any oath taken for the application in accordance with such a direction is in order. And C. The same-sex partnership registered outside Hong Kong on which the registration relies has been terminated. Clause 12 is about both parties agreeing to have the registration revoked. And Clause 14 is about revocation of registration by registrar on own initiative where same-sex partnership has been terminated overseas or outside Hong Kong. So clauses 12 and 13 are very similar to each other. It's just that clause 13 is about situations where the registration made overseas has already been terminated. Clause 14, revocation of same-sex partnership registration by registrar on own initiative where same-sex partnership has been terminated. The registrar may, on the registrar's own initiative, revoke a same-sex partnership registration in accordance with Section 16(2) if subsequent to the registration, the registrar is satisfied, based on any information regardless of how it is obtained, that the same-sex partnership registered outside Hong Kong on which the registration relies has been terminated. So this is about situations where registrar has received reports or information that the same-sex partnership had been terminated, and then the registrar will have the power to revoke on his own initiative the registration. Clause 15, date on which revocation of same-sex partnership registration takes effect. 1. If the registrar revokes a same-sex partnership registration under Section 12(5), the date specified in the same-sex partnership revocation of registration certificate is the date on which the revocation takes effect. 2. If the registrar revokes a same-sex partnership registration under Section 13(5) or 14, the earlier of the following is the date on which the revocation takes effect. A. The date specified in the same-sex partnership revocation of registration certificate. B. The last date of the 6-month period immediately after the date on which the same-sex partnership registered outside Hong Kong on which the registration relies is terminated. I see that 4 members have asked to speak. Mrs. Regina Ip. Chairman, my understanding of the difference between clauses 12 and 13 is that clause 13 is about situations where the same-sex partnership registration obtained overseas has been terminated. The basis of this bill is that there has to be a partnership registered outside Hong Kong. And clause 12 is about situations where the partners can, on their own initiative or wish, have the registration revoked. Well, what about the partners are just having a quarrel or a fight, and after they've asked for a revocation of the registration for a month or 2, they want to have the registration back? It could be an emotional decision. So my question is clause 12 necessary? The couple may just be having an emotional time and they ask for their registration to be revoked, and what if on the following day they ask for the registration back? Deputy Secretary, indeed in real life there might be such situations. You see that we are giving applicants or the same-sex partners a certain degree of flexibility. We trust that any people who come to ask for the registration revoked do that on a genuine basis. If your registration has been terminated overseas and you ask the registration obtained in Hong Kong to be revoked, this is acceptable. If both parties have thought it through and they decide to have the registration revoked, we'll have to offer such option to them. This is because they may not be able to go overseas or to the relevant jurisdiction to have the registration revoked immediately. If both parties tender application to the registrar, then this would be accepted. But if they are simply having a fight, they haven't thought it through, and the revocation certificate has not been issued and they want to cancel their application, we might exercise discretion and accept that they do not want the registration revoked. Well, what if both parties have asked for the registration revoked and years later they decide that they are right for each other? So will you allow them to have the registration back? I understand what Mrs. Regina Ip is saying. I have to reiterate that both the application for registration and the revocation of registration is a solemn matter. We want both parties to think it through before they tender the application. If years later they decide that they want the registration back, we will provide them the option to tender an application to obtain the registration again. Dr. Eric Yim. Clauses 12 and 13. Well, registrars are acting on behalf of the government. Both title is about revocation of same-sex partnership registration by registrar on application. Well, it should be up to the parties to decide whether they want to submit the application. I think the wording should be revised here to show that it is the applicants who tender the application, not the registrar making the application. Also, I agree that both parties should think it through before they tender the application. Should there be a cooling period for the applicants? In the mainland, there is a cooling period for applicants. Will you consider setting up a 30-day cooling period for applicants? And only after the cooling period that you will allow applicants to have the registration revoked. Also, what if the registration is revoked in Hong Kong and the registration obtained overseas is not revoked? Will the registration obtained overseas still be valid then? Deputy Secretary, I thank Dr. Eric Yim for the questions. On the title of clauses 12 and 13, I'll ask the Department of Justice to supplement. On the question about cooling period, if the registration system is implemented, we may not necessarily set up a cooling period, but we will remind applicants when they come to the registrar's office to think it through before they submit the application. We will remind them of the procedure involved and the consequences. So the applicants will be responsible to think about the changes after they have submitted the application. Also, both parties to the partnership may come to have their registration revoked. They may first have the registration obtained overseas revoked first before they come to us. I think this will meet the needs of the applicants. I will now ask the DOJ to reply to the question about the titles of clauses 12 and 13. Yes, DOJ. Here, the registrar will revoke the registration based on the applications made by the applicants. So this is different from the registrar revoking the registration on his own initiative, as in clause 14. But if you look at it in Chinese, the word ying gives people the impression that the registrar finds it necessary to revoke the application, and this is very different from the word registration by registrar.
Dr. Su Cheng-Wing. Thank you, Chairman. I'd like to ask about clause 13. One side of the partnership may apply to revoke the partnership. Will the other side of the partnership be informed? Otherwise, the other side or the other party may still think that there is still a registration valid. Regarding clause 14, the registrar may, on the registrar's own initiative, revoke a same-sex partnership registration in accordance with Section 16, brackets 2. I'd like to know whether the registrar will verify with the applicants first. I'd like to ask about clause 15, brackets 2, A, B. I don't understand the dates here. Can the administration let us know how you arrive at these periods? Administration, thank you, Dr. So, for your questions. Thank you, Dr. So. In relation to clause 13, we issue notice to both sides or both parties of the partnership. We let the other side know that there is such an application. Do you inform the other party after revocation of the partnership? Well, before the completion of the revocation procedures, we inform the other party to the registration. At least we let the other party know that there is such an application. Regarding clause 14, we have the phrase regardless of how it is obtained. Therefore, we will verify with the applicants. For instance, when we receive a document from the court informing us that the registration has been terminated or the partnership has been terminated, then we will inform the parties to verify such determination before we decide our future course of action. For the third question, I'd like to invite Ms. Wong to take it. Please switch on the mic for Ms. Wong. Please speak into the mic. Thank you, Dr. So, for your question. Regarding clause 15, brackets 2, A, B, regarding partnerships outside Hong Kong have been terminated, then the registration in Hong Kong will also be revoked and be declared null and void. The last date of the 6-month period immediately after the date on which the same-sex partnership registered outside Hong Kong on which the registrar relies is terminated. If a partnership registered outside Hong Kong is terminated, and when a party applies for the revocation of the registration, when the registrar approves and issues the revocation certificate, if this happens within 6 months, of course, the date will be the last date of the 6-month period. We need to show respect to the applicants. However, in other circumstances, for example, when the applicant applies only after 6 months of 6 months after the termination of their partnerships, then the date concerned will also be the last day of the 6-month period. immediately after the date on which the same-sex partnership registered outside Hong Kong. Thank you. Mr. Tang Fei. Thank you, Chairman. Mr. Eric Yim asked the question that I wanted to ask. From clauses 12 to clauses 15 is about the termination of partnership registered outside Hong Kong. Then this will lead to the revocation of the registration in Hong Kong. Divorce is complicated. It will involve the distribution or assignment of the assets outside Hong Kong. Let's not talk about that. Let's just talk about the revocation of same-sex partnership registration in Hong Kong. When one party makes such an application whereas the other party does not agree, can one still make such an application? Or can one party resort to legal means to suspend the application for revocation of same-sex partnership registration? Deputy Secretary, when one doesn't terminate the same-sex partnership registered outside Hong Kong, then we require both parties to come to us. They cannot just ask one of the parties to come to us. Regarding other means to deal with this, then this will be decided by the applicants themselves. When they need to revoke the registration in Hong Kong, there are only two options. One, you have to prove that your same-sex partnership registered outside Hong Kong has been terminated, or you need to come to us to make such an application. You need to take an oath each. Thank you. Mr. Peter Shield. Now, for the registration of same-sex partnerships bill, the basis is that one needs to have registered outside Hong Kong. However, when applicants divorce outside Hong Kong, but they do not inform you in Hong Kong, then they don't have the basis to apply for the registration of same-sex partnerships. In this case, is there any penalty? I want to know why someone will have to wait for 6 months before they can apply. If someone files for a divorce outside Hong Kong, can they tell you immediately and revoke the same-sex partnership registration? When a pair of couple divorces, or just assume one party has already passed away, then one may make after-death arrangements for the other party. So why does one still need to wait for 6 months? Ms. Wong, thank you. 3 questions. For same-sex partnerships or marriages registered outside Hong Kong when they have been terminated, and when the registrar's office is not made known to this, when it comes to the responsibility under clause 11.1, we make it very clearly. We set out very clearly that in this case, the applicant will have to inform us immediately, otherwise he or she will be subject to criminal liability. There's a grace period in which probably documents will have to be handled. That's why there's a grace period. After the passage of the bill, we will provide very clear guidelines on the criminal liability or grace period. We will also set out clearly the consequences. I'd like to ask the legal advisor to talk about some points. Just now, the provisions are about the registrar's decision to revoke registration. However, there is no appeal mechanism in relation to this. Members, please take note, or any other thing to be added by the administration. Deputy Secretary, under this registration mechanism, applicants will have to meet all 6 registration requirements. When the registrar considers the application, the registrar will have to consider the documents and information submitted by the applicants. The registrar will have to see whether the documents are issued by statutory or official organizations. The registrar will also have to consider whether the applicants have taken an oath. The registrar will verify the copy, certified copy, and check the oath-taking procedures. These are objective facts and objective procedures. Therefore, I believe there isn't much room for argument or dispute. That's why, under this bill, we don't find it necessary to provide for an appeal mechanism. Our third meeting is about to end. Let's take a break for 15 minutes. At 10:45, we'll come back and start our 4th meeting of this Bills Committee. Thank you.